Hey everybody, hope everybody is doing well. We have two new filings on the Courtney Clenney docket. They're pretty short, so we're going to read through them in full. And we're going to read them in the order they were filed. I haven't read them, but because one is a motion for sanctions and motion to compel, there's an interview that Court TV did with Clenney's defense attorney, Frank Prieto, after the last hearing. I think this interview was December 21st of last year. So there was a part of it where they talk about the video footage, the surreptitious recordings, and whether or not they will be admissible at trial. And as anyone that's following this case knows, it's something that the defense, Courtney Clenney's team, has been fighting to keep out since the very early days of motions in this case. Well, we're going to use this bit of an interview as some pretext for the motions we're going to read. And I want you guys to take a food for thought sort of exercise. Despite what you may think based on what you know about this case, I want you to put on your juror hat and imagine if the defense succeeds in getting rid of some of these recordings. The jury doesn't get to see the things that we've gotten to see. Do you think that's going to be impactful? So let's get this little clip here going with Frank.
The videos that are out there that show your client and Mr. Obumseli quarreling, fighting, sometimes it's physical, sometimes it's just, yelling, all of that. Will the jury see all of that? Or are you trying to restrict some of it? What's the defense strategy in terms of what you want the jury to see and what you don't?
Right. Well, the videos, the media and actually the state attorney's office at their initial press conference, right, the infamous elevator video is actually helpful to us. What people don't see is, and I know you have the elevator video coming up.
Cue it up. Yeah.
Prior to this, when Miss Clenney gets on the elevator by herself and goes down to the lobby, because this is when she got back on the elevator from the lobby to go upstairs, she's actually, when she moves out of the elevator, you see there's a puddle of blood. She was injured when she got onto that elevator, which is why she was so adamant to not have him go back up, because he had the only key fob. And with that key fob, he has direct access to his apartment, and she had actually gone down to call the police. So when we show the actual beginning of this video, not just the snippet when she gets back on in the lobby, the jury's going to understand she was injured, went downstairs to get help.
So we've heard, I think, last February, maybe February 2024, we heard the parents in an interview. We heard Frank Prieto speak to their version, their interpretation of what goes on in this elevator video. And I would say probably like 85% of the chat, the comments, at least on this channel, which we might have a certain lens through which we're looking at this case. People were like, we don't really agree with their interpretation of what they see in this elevator video, for the most part, right? The general sentiment here seems like this particular video, the defense still wants to keep in. But what about the other ones?
And then decided not to call the police when he showed up in the lobby. So there's a lot of backstory that the jury's going to hear that is not out there. And those recordings that have been played as well, those are 100% inadmissible. And in fact, Judge Cruz should not have even listened to those.
So he makes this extra comment here that Judge Cruz, Laura Sharon Cruz, who handled a lot of the pre-trial back and forth. Now we're going to have Andrea Ricker Wolfson as the trial judge. But Laura Cruz, he's saying, watch some of this footage. And I would think the reason that's top of mind for him is maybe that footage is what played a role in some of her decisions on different rulings, including perhaps the first and second motion for bond. And also because, judges don't typically want to undo what a different judge has already done without good reason. Judge Cruz's ruling necessarily bears some weight on what Ricker Wolfson was going to do with the third motion for bond. I think it's third. It's hard to keep track.
The surreptitious recordings, I think Julie Grant had also asked about this many moons ago. They're inadmissible. Florida's a two-party state. You cannot surreptitiously record anybody. It is per se not admissible evidence. So that will be thrown out.
So there we go. I linked to this in the description if you want to watch this full video with Court TV. They go over some other subjects, but that's what's relevant to what we're going to look at here with one of the two motions. We're going to look at both motions, but the first one is this motion to compel and for sanctions. And I saw the first paragraph and I'm like, please tell me the state isn't going to be messing this up again. But I think they might have messed up again. The last two hearings we got updates from, There was a lot of planning back and forth. Can you do this certain thing by this date? Well, we need a little bit more time. How about you set a deadline for January 13th? Blah, 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 blah. And all of that stuff was mapped out. And I think we missed some deadlines. I think the state missed some deadlines here. So defendants motion to compel and for sanctions. So they filed this right on January 13th, 6:43 p.m. Comes now the defendant, Courtney Clenney, the defendant, by and through undersigned counsel, hereby moves for entry of an order compelling the state of Florida to abide by this court's scheduling order and awarding defendant's attorney's fees and costs and bringing this motion pursuant to the court's inherent powers, awarding fees, governing law, and for good grounds would state the following. On or about December 5th, 2025, so one of the hearings. This court issued a scheduling order regarding pending defense motions, including, inter alia, defendant's amended motion to suppress illegal recordings filed on October 12, 2025. The state of Florida was ordered to respond to said motion by January 9th, 2026 by 5 p.m. We have a footnote. The state of Florida has also not timely responded to prior deadlines concerning this court's scheduling order of December 5th, 2025. The state of Florida's failure to timely respond to pending motions and disregard for this court's orders continues to delay these proceedings, preparation of Ms. Clenney's defense, and ability to formulate a proper trial strategy. As of the date of this filing of this motion, the state of Florida has not filed or otherwise responded in writing to defendant's motion to suppress illegal recordings. The state of Florida has also not sought relief from the deadline nor contacted undersigned counsel to seek an agreed extension. There are currently 2 assistant state attorneys, ASAs, assigned to this matter. You have the Chief Assistant Kathleen Hogue and Division Chief Sean Abahoff. It is not uncommon for additional prosecutors to be assigned to cases where the lead attorneys are not able to timely handle motions, responses, depositions, etc. This has not been done since ASA Khalil Quinnen was conflicted off the case for his misconduct. They're going to remind us why he had to go. And here, what they're doing here is saying there really isn't an excuse. There really isn't an excuse here. You have an office at your disposal. And again, I feel like I keep saying this, but imagine what this would look like for a defendant who, no matter guilt or innocence, the process should always be fair. The process should be done following the standards. Imagine if Courtney Clenney didn't have the resources for attorneys that could keep track of these dates. And hey, state, you're missing your deadlines. I think someone dealing with an overwhelmed attorney that's working kind of on their own, they might not even be able to keep track of this. So then we have the state of Florida's lack of diligence has caused undersigned counsel to bring this matter to the court's attention by drafting this motion to compel and setting this matter for hearing. This has resulted in the unnecessary expenditure of time and resources. As such, undersigned counsel requests this court to grant sanctions in the form of attorney's fees in bringing this motion. So wherefore, the defendant, Courtney Clenney, prays this honorable court grant defendant's motion to compel and award reasonable amount of attorney's fees in having to bring this motion, considering the court's inherent authority to regulate this litigation and the government's absolute failure to abide by the court's order of December 5th, 2025. So then they sign off on this. And, this is the docket. You don't see anything. We've got this lump of filings and updates from, let's see here, 12/8/18. And we do see, when we see this little date suddenly out of order for January 12th, it's because there was an update. So this line item existed and used to say that there was a status hearing set for January 20th. They had to push back the hearing. They're doing it on the 23rd now. But this used to be, that first update came on 12/18. So this isn't like a filing or anything. They just updated this line item. But we don't have anything here filed since these hearings from the state dealing with these issues. It's not on the docket. And then Courtney's attorneys are representing here. We haven't had any correspondence saying, hey, would you be amenable to more time? Or, here's informal communications, but we're working on it. So that's the representation from the defense. If this is a serious thing, that the state wants this stuff to be admissible, They probably shouldn't be missing these deadlines anyway, especially if I'm not mistaken, I really think this is one of the things Sean Abahoff at the December 5th hearing said, hey, can we do a little bit more time? And they agreed on the date of the 9th. I don't know. Why would you mess this up? Why would you mess this up? Next one, you guys. We've got defendant's motion to strike state's expert witness Michael Brandon, PhD, and request for in-camera review. And remember, in-camera review is that like weird in-camera review. We don't actually get to see it. They do it in the judge's chambers. So it doesn't mean Court TV, Law and Crime get to be there and we get to watch the stream. So weird wording. Comes now the defendant, Courtney Clenney, by and through undersigned counsel, moves to strike the state's designated expert witness, Michael Brandon, PhD, and requests an in-camera hearing and review of confidential settlement materials relevant to bias and conflict. On October 7th, 2024, the defense filed a notice of intent to rely on battered spouse syndrome and listed Dr. Lenore Walker, who is where we get the academic theory. The coining of the term battered spouse syndrome is from Dr. Lenore Walker, and Dr. Stephanie Ackle as defense experts. On October 21st, 2024, the state listed Dr. Michael Brandon as its rebuttal expert witness, so they're going to bring someone in to counter all of this. At least they plan to. Due to pending litigation on the defense's motion to recuse the assigned prosecutors and the state attorney's office, the underlying data and evaluation materials relating to Ms. Clenney generated by Drs. Walker and Ackle were not turned over to the state during that period. That litigation is now concluded and a trial date has been scheduled for April 27th, 2026. And that has not changed. So there's no change to the trial date. That's still the same, still April 27th. Dr. Brandon and Dr. Walker were prior adverse parties in civil litigation, creating a conflict that warrants striking Dr. Brandon as a state expert in this case. So let's see, what is this tussle? What are we going to learn about Dr. Lenore Walker and Dr. Brandon having some like separate civil litigation beef? So on July 26, 2004, Dr. Brandon filed a civil negligence action against Dr. Walker in Broward County. Dr. Walker filed a counterclaim in that action. The case was ultimately dismissed by stipulation with prejudice in or about May 2006, and the parties entered into a settlement agreement. The settlement agreement is confidential. So I think they're going to say, like, we can't cross on potential motive. Like, what if you're here just testifying as an expert witness because you have a beef with Dr. Walker? Dr. Walker was listed first as a defense expert in this case and is a central expert witness on the battered spouse syndrome theory. The state has listed Dr. Brandon as its expert to address, rebut, or critique that defense theory and the work of Dr. Walker. A prior lawsuit between Dr. Brandon and Dr. Walker, resolved by a confidential settlement, creates an appearance of bias and conflict that cannot adequately be explored. Now, I know this seems like, if you see me smiling, it's because this is such, like, to me, it's like a really nuanced thing to file a motion about. But at the same time, I kind of can pick up what they're putting down because you can't confront the other witness on what would be the terms of a confidential settlement. So can you properly cross-examine this expert witness now? Like, like, I don't know. It's out there. It's a very particular argument to make, but okay, we're making it. So they say this conflict cannot adequately be explored in open court without risking disclosure of confidential settlement terms. Yes, the underlying drama. The underlying drama. If Dr. Brennan is permitted to, and I should really say Brannon, not Brennan. If Dr. Brannon is permitted to testify, the parties and the court will be placed in the untenable position of litigating in front of a jury whether and to what extent his testimony is influenced by or conflicts with obligations arising from a confidential settlement agreement. That circumstance risks unfair prejudice to Ms. Clenney because the jury could infer improper motives, undisclosed wrongdoing, or other matters unrelated to the facts that the jury must decide. And what I think is interesting here, like, again, it's not every day that you see a prosecution team trying to counter the idea of battered spouse, or calling in a DV expert to explain why a victim might have engaged in certain behaviors, right? So, for example, if somehow this was a trial where Christian Obumseli was on the stand, I wonder if the prosecution would be trying to look at Courtney Clenney as a victim, right? You guys get what I mean about the role reversal? You know, typically it's the prosecution that has to explain, you know, why maybe an ex continued to go back to their partner, stayed with their partner if they were really being abused. Well, here's someone that explains the dynamics of toxic relationships and how there's a power dynamic and why someone might not act the way you expect. All right, so I think there's a little bit of role reversal in this case, and it's unique to see in this. The woman's on charge, on trial, and it's the defense bringing the expert witness. So we've got, let's see, becoming a reality show. It might have started with this all being an OnlyFans, and I wish I could remember because it was another person, like it was her social media. She posted a video. And she's not like an influencer or anything, but she posted on her own like personal Instagram account that video of Courtney Clenney drinking or at the hotel bar with her father just a few days after Christian Obumseli was murdered. Like, I think without that post, we might not have seen enough call to action for the state to do something, because they didn't charge her at first. They looked at it like, hey, this was justifiable use of force. This was self-defense. We believe her. But then I think the public pressure made the state feel like they had to bring these charges finally. But it seems like the state was afraid to press charges against. In my opinion, I think there's a gender role there. Just my opinion. So we've got Florida statute 90.608 expressly provides that a witness's credibility may be attacked by showing bias. That rule applies equally to expert witnesses. Section 90.403 Florida statutes authorizes the court to exclude otherwise relevant evidence when its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. The state will likely argue that any bias or interest on the part of Dr. Brannon can be explored through cross-examination. In this case, however, that remedy is illusory. The conflict at issue arises from a prior civil lawsuit and a confidential settlement agreement between Dr. Brannon and Dr. Walker. The terms, the scope, and effect of that settlement cannot be publicly disclosed without violating confidentiality obligations. As a result, the jury would hear Dr. Brannon's critique of Dr. Walker without being able to fairly evaluate whether and how his testimony is influenced, constrained, or motivated by that settlement. This places the court in an untenable position. Either the jury is exposed to confidential settlement issues that risk creating improper inferences and collateral prejudice, or the jury is shielded from the very information necessary to assess the credibility and neutrality of the state's expert. In either scenario, the testimony becomes misleading and unfairly prejudicial within the meaning of Section 90.403. This conflict also detracts from the real issues the jury must decide and invites collateral litigation over matters unrelated to Ms. Clenney's conduct. If they were to have to get into any confidentiality, like the settlement terms, that would be the confusion of issues. The state will not be unfairly prejudiced by exclusion of Dr. Brannon. Dr. Brannon has not evaluated Ms. Clenney and has not reviewed the evaluation records or underlying data generated by Drs. Walker and Ackle. Accordingly, the state has expended no money, or at most, only limited funds in connection with Dr. Brennan's designation. So here we go. This is the remedy, the sensible remedy. The state has other expert options available. For what it's worth, I would love to see a prosecution team call what I suspect, my guess, I don't know about Dr. Brannon's analysis, but in the context of why the state would want to call him here, my guess is he's a critic of the theory of battered spouse syndrome. And I just think it'd be very interesting to see a prosecution team, call someone that opposes something that the state frequently relies upon. So I don't know. That's just me wanting to see the chaos. So to the extent the court determines it must review the settlement materials to assess the nature and scope of the conflict and potential bias, defendant requests an in-camera hearing and in-camera review of the settlement agreement and any narrowly tailored materials necessary to assist the court in ruling, with appropriate limitations to protect confidentiality. The state opposes this motion. So this means they tried to talk about it with the state, and defense already knows that they're not willing to budge and get a different expert. So wherefore, defendant respectfully requests that this court enter an order conducting an in-camera hearing and in-camera review of the confidential settlement agreement, striking Dr. Michael Brannon as the state's expert witness, and granting such other and further relief as just and proper. So that was filed on the 14th. So there we go. We've got our docket updates here for Courtney Clenney. Again, that hearing that was set for the 20th is now going to be on the 23rd, but the trial is still, it hasn't moved. The trial date is still April 27th. So, and what are you guys thinking over here? I see Ariane the Vegetarian says, that makes me think of Dr. Hughes. Yeah, very interesting. Very interesting. If you guys did not watch the Depp v. Heard trial, one of my favorite expert witness cross-examinations is the cross-examination of Dr. Hughes. And maybe we'll watch that, like, when we're watching the Courtney Clenney case, maybe we can watch Wayne Dennison's cross of Dr. Hughes during one of the lunch breaks. Because I really enjoyed it. I mean, you find out that Dr. Hughes, and she keeps saying she, when she's describing general examples of abuse, the way she's speaking, she's always applying the she pronoun to apply to the victim, and the he language, the he pronoun, to apply to the perpetrator of IPV, of interpersonal violence. And it was interesting to see, like, you would think you would try to not speak that way if you wanted to come off as not having a particular inclination. And even though statistics might say that more often than not, well, that's not the right way to word it, that there's the proportion of victims of domestic violence, there's some disagreement out there, but most people think women more often the victims of domestic violence, and the assumption is that the perpetrator is male. Now, there's really interesting statistics about, like, female partners, where both partners in the relationship are female, the rates of domestic violence in those types of relationships. So it gets really nuanced, and my quick opinions here, I don't want anyone to think I'm making any conclusions. But I'm just saying, there is this idea that statistics would show more often than not, the woman's probably going to be the victim in a scenario. And the reason I think that's important is I think that's the way prosecutors approach investigations. There's that lens there. And maybe that ends up being true a decent percentage of the time, but I think it makes it more likely that they will overlook a situation where that isn't the case. Which is, again, I think that's a factor in why we didn't see Courtney Clenney charged right away. It took months. So, and then again, I think it's interesting, we're going to see the battered spouse syndrome defense apply to Courtney Clenney here. And I think the general sentiment in public, the majority of people think that she's guilty and what she did was unjustified. And unfortunately, some of the opinions that I see, and I don't agree with them, they're actually the type of thing that I don't think I'd allow in the chat. I've seen some comments that she's probably guilty, but then they say a horrible thing about the victim. So it's kind of like, free her because screw the victim. Which to me isn't really we think that Courtney Clenney was the oppressed here. So beyond those two groups, there is a small percentage of people that think, like, no, I think Christian Novoselic was actually the abuser. And whatever happened in that moment is going to lead to a justification of what she's charged with doing. So, but I think it's really unique to see a scenario where we have the state fighting against this type of dynamic. So that's probably why I've been interested in this case. We've got, let's see. We've got Mavka saying anyone can be abused domestically, even parents by children. Yeah, elder abuse is a whole category. Elder abuse is a whole category. And it's not just constrained to a family relationship, but elder abuse is an entire category there. And sadly, a lot of intertwining with wills, inheritance, the estate, right? Even there's some elder abuse cases where caregivers, someone who lives in the home and helps take care of an elderly person when they need that daily, like almost 24/7 companionship because of their health. They can't walk around the house. They might fall, and then that's never good when an elderly person takes a fall. There's a few cases I've come across where a caretaker is accused of elder abuse, doing manipulative things to get that person to put them in the will and write everybody else out of their will. So a whole category interesting out there. And there's attorneys that specialize in the field of elder abuse law. So very big consideration there. We've got 99 saying, hey, good morning. This case is taking way too long. That's why I keep saying, hey, we didn't have a change in the trial date. The trial is still on. The trial is still on. Good to see you, Keith. Good to see you, destined to be. Dee says the au pair trial is something. And that's another interesting case where I think if he's guilty, I think she's guilty. And bothers me a little bit. If she's going to get time served, I can picture the au pair going and doing something else horrible to somebody. I don't think it's a situation where she had no choice. And I think there are situations where that would be the case. But based on what I've seen from the au pair herself, her own testimony, if her story is true and she's just not in a position where this isn't what happened, that there actually was an intruder, but she's saying it was a plot because she wants to get out of jail and thinks a jury would convict her, then that means she's guilty of shooting someone in cold blood and planning to coordinate the death of 2 people total. So I think that's another exceptional example of, statistics should not be the lens through which we look at the individual facts of an individual case. So let's see. We've got, she's been violent for years, and yet Wayne Tech, take us back to the initial question at the beginning of this video. Like, what do you think the impact if some of these other videos don't come in? Either because they're recorded in a 2-party state, they're recorded surreptitiously, and, the judge agrees that there's an expectation of privacy. Or what if maybe the judge is on the fence, but we're getting close to the final hours and, hey, you're not meeting your deadlines. You're messing up. So that can't come in. Some of the stuff that we've seen in journal notes, what if that can't come in front of the jury? Because for me, the idea that she's writing journal notes to herself saying she's hitting Christian just to relieve tension, that's not self-defense. Hitting someone to relieve your own anger and frustration and tension is not the same as I'm frustrated because he's always putting his hands on me. That's not what she writes in her journal. But I don't know if the jury is going to see what I've been able to see on the outside. So contrast that with the au pair trial where I don't know any background. I went into that like, hey, let's just watch a case casually. Can't be that crazy, right? Different approach. Like I'm learning as we're seeing the testimony unfold. Courtney Clenney, I've done such a deep dive that if we don't see that stuff come in at trial, I'm going to be like, oh my God, the jury's in the dark. The jury has no idea. So that'll be a time. That'll be interesting for sure. And let's see. Martina Nem says, I think the elevator one is enough to get the picture. I agree. I think so too. I wish I could see the future and see exactly how that plays out. Like, are they going to run through that elevator video with Courtney Clenney on the stand? Because Courtney Clenney is expected to testify. So she is expected to take the stand. It seems like she's going to try to do a walkthrough with a 3D modeling of the entire apartment unit to explain what was happening in those moments. Like, here's the kitchen island, here's the kitchen table. I was over here when I flung the knife, and Christian was over there. Like, she's going to use this model. She's going to have to explain it walking through. So, I don't know. I think it'll be her describing the elevator footage. And she's going to have to explain what justifies just wailing on somebody. Mafka says, even if she has a history of violence, doesn't mean she couldn't have been put in a situation by him that required deadly force. That's true. And I think that is her strongest point, is nobody else was in that room. Nobody else was in that apartment. So he said, she said, and remember, criminal trial. All it takes is one person on the jury to say they don't think the state's met their burden, or that they think she was justified. Yeah, and you could end up with a hung result. So I think it'd be very hard to imagine 12 people acquitting Courtney Clenney. But I don't think it's very difficult to imagine at least one person wanting to either say it was justified or just say not guilty, like we didn't even meet the elements of murder 2. So Brooklyn says, I wish I could unsee the elevator clip, but I can't. Well, good news there is it seems like nobody has a problem with that coming in at trial. So the jury should be able to see that. So you can still like have your jury hat on and not know too much. So yeah, Law Nerd Amber says the medical examiner testimony is going to be critical for the prosecutors. And I mean, knife throwing expert, knife throwing demonstration, I guess critical for the defense. So we've got, let's see. Yeah, Mavka says the M2 charge is insane. It's manslaughter at worst. So another thing worth saying out loud is I would imagine the jury would be able to consider lesser included. So the issue with that, Mavka, so say for example, you're saying manslaughter at worst. I think when there's murder 2 and then there's a lesser included of manslaughter, someone that might not really be all the way there for manslaughter might be willing to go for manslaughter if it means coming down for murder 2. And, that's a whole rabbit hole conversation, right? Like the inclusion of lesser includeds, how often does that create a compromise verdict where if it was just a matter of the top charge, or if it was just a matter of a lesser included with no other options, would the result be different? Would the deliberations go differently? So, yeah. And I Am Tetsuko says, so many true crime channels have tainted my opinion of the case. It's like that. I mean, I'm part of that because I've been covering things that are, there's absolutely no way that like every single journal note, every single thing that we've looked at is going to come in at trial. Just as a matter of practicality, the trial would take months. So, but yeah. And there we go. Look, see, we're getting like this, hey, manslaughter. And then again, like, if the facts support manslaughter and that's what the jury comes to, that I support the jury system. But then I'm also like, lesser includeds create this kind of conundrum. So, and then we've got, let's see. And Gwennon says true crime channels should be banned from telling a defendant's story before trial. I still support the, as long as people have they're relying on information. They're not just trying to put some razzle dazzle for the sake of it. I don't mind what anybody really does as far as coverage. What I do think is important is that anything that you take in, wherever you're consuming it, everybody should exercise their own due diligence. And part of what's great here, again, I've said with this particular case, I think the sentiment is around like 80%. We don't think, I'm in that 80%. We don't think that 80% of us, we don't see just like a straight acquittal for Courtney Clenney based on everything that we've looked at. But that other 20% that's part of the chat, again, minus those opinions where it's just like, well, we don't care because we didn't like the victim. Like, I'm putting them over on their own island. They're not part of this conversation. Like, I don't know. We didn't tolerate that with YSL either, right? When we were watching the YSL trial, none of our opinions about whether or not the state was proving their case, whether the state was, acting unethically. And that was never meant to be a slight to those that lost their lives or the loved ones of those people that lost their lives. But there would be, and it really wasn't that common, surprisingly. But there would be some comments that would come along that would be like, who cares? And, I don't know. That's not my vibe here. That's not my vibe. So, yep, and everybody is biased. There is no such thing as unbiased. And I've watched people change their opinions. Even here with, hey, maybe it's more likely manslaughter. The language, I agree it's more likely. That shows consideration. It's not someone coming in here with a straight belief and just sticking to it. So, there we go, you guys. I wanted to do this as a live because I figured if I recorded it and tried to edit it and get it published, I would take forever and I wouldn't put it out for a few days. So this is a quick unplanned live. I was actually over watching the Uvalde trial with Nick and Mo, so I'm going to get back over there. Bittersweet says I'm not a fan of Courtney, so I can't watch this trial. Well, it's not a trial for only fans. You can watch it even if you're not a fan, if you get where I'm going. But I understand. And not every trial is for everyone. So, Iceman says, Kat, as odd as this may sound, if you have younger guys who may have seen her on OnlyFans, they may be willing to not convict with the thinking, is this still part of the show? Just my opinion. Never underestimate the power of simping. So, there's a case I covered very early on this channel where the descriptions of the jury pool. There was a juror with a comb over that always seemed like he was smiling. And sometimes it was described as smiling in a creepy way at the ex-girlfriend of the defendant while she was testifying. So, and to me, I think that was a compromised verdict case. And, maybe he has just resting simp face. I don't know. But that was the description from observers that were sitting in court. And it was like, I really think that happens. You never know. You never know. So, so there we go. The power of simping. You never know. So that being said, I'm going to head back over to Nick's. This is going to redirect, but if you don't want to watch, it's a sad trial. The Uvalde trial, a horrible, horrible tragedy. And then I really think this drawn out prosecution, it's just, I wouldn't want to be one of the parents having to sit here while this trial was playing out. But as far as the presentation, the legal analysis, it just seems like it's a drawn out prosecution against one guy, which just to me just seems like not the best use of prosecutorial discretion, especially since everybody that might be having heightened emotions or thinking about that day all over again have to sit there and think about it for the duration of this trial. So don't come along and watch it with us if you don't want to watch a sad trial about what happened to children. So, but that is where we're going to go. I'm going to go over there and see what's going on, catch up with Nick and Mo, and I'll keep an eye on the docket. If it's just like a simple little tweak, I'll make a community post or something so you guys see it. And Tuesday, I think, right, Tuesday, we'll be back for the au pair trial. We'll be back for the au pair trial because they don't have court today or Monday. State is already going to rest their case. They have 2 more witnesses. One's only going to take an hour. The other, they said, about 15 minutes. So they have like an hour and 15 minutes left of questioning for their last 2 witnesses. And then it's on to the defense. So I don't know. That's a case I got into accidentally because it was Judge Penny from the Depp v. Heard trial. And I heard that there was some infighting over digital forensics. So I was like, cool, let's check it out. And that has been a wild ride. So we're gonna continue with that on Tuesday. In the meantime, catch you guys somewhere in these YouTube streets. Nick for now and whoever else the rest of today, tomorrow, and Sunday. So you guys all have a good one. Please take care and good to see everybody.